the question is that this bill be now read a second time. The member for Wright.
Thank you, Mr Deputy Speaker. I rise to speak on the Corporations Amendments Phoenix and Other Measures Bills 2012. Predominantly it's broken up into two sets. The first set of measures contained in this bill strengthens the powers of the Australian Securities and Investments Commission, ASIC, to place companies into liquidation, and the second set of measures in the bill sets to facilitate future requirements of public notices and corporate internal administrations to be published on a single publicly available website. Mr Speaker, this bill is meant to enhance the ability of Australia's Securities Investment Commission to combat a product called Phoenixing activity. The bill gives ASIC significant new discretionary powers to place a company into liquidation. These powers can be used in a range of circumstances. If a company is 6 months late in responding to a compliance notice and has not lodged neither Corporations Act documents in the preceding 18 months, ASIC has the capacity to wind it up. ASIC has no reason to believe a company is carrying on a business, and no objection to liquidation is received from the directors. A company's review fee has not been paid within 12 months, or a company has been re-registered in the preceding 6 months, and ASIC has reason to believe that it is in the public interest to place the company into liquidation. The bill also alters the publication requirement of corporations' insolvency notices to allow for publications on a single ASIC administration website. Finally, the bill establishes a duty of receivers, administrators and liquidators to notify the Secretary of FASIA upon the appointment to the company that is a paid parental leave employer. Phoenix activity occurs when the director of a company deliberately misuses the corporate form with the intention of denying unsecured creditors access to the asset of the company in order to meet their unpaid debts. Typically, the activity is associated with directors who transfer the asset of an indebted company to new companies which they are also directors. The directors then place the initial company into administration or liquidation with no assets to pay employees' entitlements or to pay creditors at the tax office, then carry on merrily conducting business in the new company structure. It costs millions to the economy, or billions to the economy. It costs the economy billions of dollars a year, and despite a multitude of reforms in the past few years, Phoenix activity remains strong. Research from Dun & Bradstreet reveals that 29% of companies that become insolvent, and in 2009 had at least one director who was previously involved wound up entity, compared to just 10% during the 2004-2005 financial year. The coalition, Mr Speaker, is overwhelmingly, does not support the activity of Phoenixing, where businesses are using the current, are breaking the current legislation or the current rules that exist to either profit for themselves at the expense of employees. So there's no way that the coalition supports that type of behaviour. However, we do have concerns with the method of which this bill presents more legislative powers to ASIC to administer what we don't believe will meet its final objections. According to the Australian Tax Office, there are about 6,000 Phoenix companies in Australia, and from 7,500 to 9,000 directors who will have personal liability under this legislation. The point with the 6,000 Phoenix companies that I want to make to the House is if there are 6,000 Phoenix companies and they're continually doing it, why is it with the powers that exist with the tax office and already exist with ASIC, how is it that these companies are able to walk in the very next day and get a new tax file number? I mean, it beggars belief from a business perspective as to how they can do that. There are so many other tools available to departments, to government, to try and prohibit this. I mean, the regulations that are being put forward as a measure to try and curb Phoenixing in this bill is like what's the saying? The sledgehammer to break a walnut. I mean, there are so. If we just applied some common sense to this, we would get a far more effective outcome. And I've asked that question in inquiries and with the Treasury and with taxation, and no one can answer me. So I find it difficult to, anyway, I find it difficult to comprehend. Phoenix activity was first exposed in 2001 during the Coal Royal Commission on Corruption in the building and the construction industry, which uncovered at least 18 cases of it. Since then, it's been identified in several other industries, most notably property, information, technology, telemarketing and other labour-intensive industries. Of course, the Coalition is strongly opposed to the kinds of fraudulent activities and supports all measures to stamp it out. Phoenix activities can have a significant impact on suppliers, contractors, customers, employees who are denied their entitlements, and if unchecked can erode the reputation of Australian business community and reduce the confidence of our world-class corporate regulatory framework. However, it's disappointing, Mr Deputy Speaker, to see the government approaching this issue in their customary ad hoc and confused fashion. As Australia's corporate regulator, ASIC has a rightful role to play in properly overseeing and enforcing existing legislation. But such rules and regulations need to be properly scrutinised by Parliament to ensure they are being applied in accordance with the original intent of the legislation. My concern is that this bill doesn't follow the appropriate parliamentary scrutiny for the powers provided by ASIC. One of the major contributing issues to financing activity is that the regulators are not fully utilising the powers that already exist available to them. Other issues including a lack of prosecution and under-resourced regulators, insufficient follow-up on complaints, inadequate penalties to act as a deterrent. In this context, Mr Deputy Speaker, the need for additional new ASIC powers seem exceptionally flimsy. It often seems, Mr Deputy Speaker, as if every second bill that comes through this place somehow involves increasing the size of the bureaucracy, and in one more government department there's going to be more bureaucrats on the ground. Whatever the reason may be, if ASIC is not currently utilising the powers already available to them, then it's pretty hard to understand why they need more. Why does this bill strengthen ASIC's powers when they're already underutilising the powers that are available to them? We fundamentally believe that part of the bill is flawed. The Coalition is also concerned that the government seems to be taking an ad hoc approach to the targeting of fraudulent Phoenix activity by introducing many pieces of related legislation in a thoroughly uncoordinated manner, by way of which I refer to the current bill and the previous bills that have been heavily criticised in the House of Economics Committee. On this side of the chamber, it is our belief that the government has failed to outline a coherent strategy for tackling Phoenix activity, and this is evident by the failure to define financing in this bill. And I challenge anyone through any of the government paperwork to go and find me what the definition is. If you look hard, you may find a legal definition on the ASIC website, but that's about the only place when it starts to get serious as to what the definition of financing is. The lack of evidence about how additional powers will better enable ASIC to tackle the problem. Ongoing concerns about the regulators not using current powers to investigate and take action. Previous assertions by the government that other actions and previous expansions of regulatory powers would be more effective, and the absence of any recognition of the role and capacity of liquidators to tackle the problem. For that reason, I believe most appropriate course of action for the government is to withdraw the current bill and instead engage some meaningful consultation to address the completely legitimate concerns of the relevant stakeholders. Only then will it be in a position to take a suitably coordinated legislative approach to what we will all agree is an extremely serious matter of public policy. As a minimum starting point, they ought to consider the proposal paper on combating Phoenixing activities released in November 2009 by the Honourable Nick Sherry, who was at that stage Assistant Treasurer. And may I add, I think since that time to now we've seen five Assistant Treasurers in our short history. Of the proposals combating Phoenix activities in that proposal paper, there were 11. There are 11 proposals. None are reflected. None are reflected in the new ASIC powers. Not one single one. it stands to reason that the 11 proposals would be a good place for the government and the new Assistant Treasurer, whoever it is, possibly tomorrow or the next day, to start when they go back to the drawing board. If the government fails to see the sense of going back to the drawing board, this bill at the very least needs to be thoroughly examined in the Senate Economics Committee. Let's be clear about this. The problem is not going to go away because business conditions at the moment are some of the worst I've ever seen them. Small businesses, start-ups last year were down 95%. How's that for business confidence, Mr Treasurer? Down 95%. An analysis done by Dun & Bradstreet found that business failures last year were up 40%. In fact, Christian is on the record of saying Australian business failures have trended steadily upwards since 2008, growing more than 30% over the last 3 years. This coincides with Dun & Bradstreet's downgrades during the December quarter of more than 128,000 firms that are likely to experience more financial distress over the coming 12 months. And when we talk about downgrading of its business confidence and the increased potential of Phoenix activities as businesses continue to find it hard to make a living, I find it incomprehensible that every day I walk into this place, we are, as opposition, we are constantly browbeaten by the Treasurer and the front bench on the strength of the economy and how great things are. Well, I encourage those members of the front bench that want to take that line about the strength of the economy, Mr Deputy Speaker, and when returning to their electorates, go and have a chat to some businesses. I had the opportunity to speak with one of my business owners the other day, employs 80 blokes, fruit and veggie, transport, and he said to me, "Scotty, I have never seen it so tough. The banks are squeezing us, and I've been around the industry for a long time. I have never seen it as tough as this." So quite a contrast from the story we hear in Parliament to what's actually out there on the street. But it's this type of economical climate where we like to see an increase in the amount of Phoenix activity and more and more businesses get into financial difficulty. This is not to defend the actions of the fraudsters who try to skate away from their creditors. It is simply to acknowledge the true potential magnitude of the problem. For that reason, it is crucial that we get this right. It is vital that we protect those small operators, contractors, employees who tend to be the victims of Phoenix activity. As currently drafted, I'm convinced that this legislation, as it sits, is not up to the job. I had some other issues there that I want to raise, but I'm going to run out of time, Mr Speaker. Go for it. What are they going? I've actually touched on it. I have actually briefed on it early in the piece, but it basically spoke to the government's position with reference to Phoenixing, with the powers that already exist to them, Mr Speaker. In wrapping up, why is it that if we have 6,000 known Phoenix operators, we're able to actually, from the government's perspective, put a number on them so we know how many there are, and we are able to name how many directors. We can put a number on those too, 7,500, 9,000 directors. Then why is it, if with the repeat offenders in this industry, isn't the department or the government or Treasury or the Australian Taxation Office or ASIC, with the powers that are available at the moment that are underutilised, allowing for these businesses just to turn around and start trading the next day by getting access to another tax file number? I just think that it's a simple remedy, and the way that the bill presents at the moment, I don't believe that the Coalition will be supporting it. Thanks very much, Mr Speaker.